Hello, and welcome to this guest lecture about legal and historical research methods. I'm Dr. Jason Shepard. I'm a professor in the Department of Communications at Cal State Fullerton and also the chair of the Department of Communications. Today I'm going to be talking a little about my own research. I primarily use legal and historical methodology in my research agenda, and I have for many years. And so I'm going to today provide some examples, primarily kind of a deep dive into my first book called Privileging the Press, which really began the first semester of my master's degree studies at the University of Wisconsin-Madison. I've posted a couple of readings on my website that might be of interest to you. One is a short 8 to 10 page book chapter called Method in Our Madness, Legal Methodology and Communications Law Research by Fred Cate. This is a really simple primer about some of the basics of legal research and analysis. And then I've also posted the preface to my book, which talks about how I became interested in the topic of journalist privilege law as a professional journalist, but then also kind of an overview of the research questions and methodology and sources that I used in that legal research that might be of interest to you. So, a little about me generally. My research agenda focuses on the role of the First Amendment in American democracy, media, and culture. Typically, my methodologies are qualitative in nature. Almost all of them are qualitative rather than quantitative in nature. And I use traditional legal doctrinal analysis and historical archival methodologies typically. And so the work that I have, the areas that I've covered in my research, broadly defined, has been freedom of the press, history and values, journalism ethics, digital media law and ethics, and then more specifically, I have several publications and years of research experience in journalist privilege law. I've published in research anonymity and privacy rights, political communication regulations, academic freedom and campus free speech, and my most recent project is about the censorship of subcultures and free expression rights of minorities. And I'll sort of end by talking about a little about that project. I try to publish and give presentations broadly and widely, not just to traditional academic journals, although I do that as well. I try to keep current by publishing a regularly updated media law textbook called Major Principles of Media Law in its 29th edition, the most recent one published in 2019. This keeps me current on a range of media law issues. One of my recent law journal publications called Culture Wars on Campus about academic freedom, the First Amendment, and partisan outrage in polarized times was a look at kind of a current controversy and legal case, and then really kind of the history of academic freedom legal developments, in addition to the role that new technologies play in resolving legal disputes. And then finally, I also write a regular online, a regular column called Online Legalities, in which I also kind of keep current on modern legal trends and cases that are in the news and in the courts. That's published by a publication called California Publisher, the publication of the California News Publishers Association. If you want to see more of my research publications, feel free to visit my website under the Research tab. But really what I want to talk about today is the book that I wrote called Privileging the Press, Confidential Sources, Journalism Ethics, and the First Amendment. The book was nicely received after I published it. It's in about 1,500 libraries across the world. It was reviewed in a publication called Journalism and Mass Communication Quarterly, in which the reviewer said, this comprehensive litany of triumphs and failures pulls together the many threads that make up the stormy history of the journalist privilege into one compact volume. If I were still working at a law firm, I'd like to make it required reading for any new associates who want to practice media law. It was also cited in the New York Times as providing a model for determining when bloggers qualify as journalists for journalist privilege protections. So this was my first book. It was parts of it were developed as my master's thesis, and then later my doctoral dissertation. And so it's nice to see that the research that I had developed over several years came together in a way that was meaningful to my scholarly peers. So the book really aimed to answer kind of three questions that I had fleshed out really in my master studies. I was thinking about what interests me as scholarly questions. I partly drew from my professional experience as a journalist. I knew that journalists sometimes needed to rely on confidential sources in order to produce high quality watchdog journalism, journalism that the government didn't necessarily want to be published. And so I used my professional experiences to develop kind of themes or interest areas. And then I began to read the literature, what's been written about this topic, what both in the contemporary trade press, but also in more traditional scholarship. And I really wanted to answer these questions. How did it come to be that journalists believe they are morally and ethically justified to go to jail to protect the identity of confidential sources? How did this professional duty develop in American journalism? How have journalists' ethical and legal arguments changed over time? And why is confidential source protection a continuing problem in journalism, ethical practice, and law? So my research questions really drove the methods and sources that I'd be using, right? So here these questions both are historical. How did something come to be? And then also normative. Why is this a continuing problem? Looking to the future, seeing how current issues might be able to be resolved. So from a legal perspective, I was really interested both in precedent, what has happened in the past, and what rules or laws have been passed and adopted and why, but also the policy analysis and the procedural analysis. What might this research say about future questions? So really, I became interested pretty early on in legal history, how historical questions and explorations can inform future practice and resolution of legal questions. And that's been really one of my primary blends of methods in a lot of my research is legal history. So in terms of the methodologies and sources that I used in this book project, qualitative methods, including legal and history, document analysis, and in-depth interviews to analyze how and why the law has changed in its social and political context. So over the course of my research for the book, I analyzed, annotated 100 court decisions, legal briefs, affidavits, transcripts, and depositions. So really trying to dig for the full picture of court cases. Some of the court cases are easy to find, certainly in Google Scholar now. LexisNexis or Westlaw legal databases is a place to look for court decisions and briefs. Some things are a little more difficult to find in terms of transcripts and depositions. I was able to track down a 584-page compilation of court documents as they relate to one particular case involving the outing of a CIA agent named Valerie Plame. That was a really important, crucial source for a chapter in the book. I went way back in history. Part of my research was looking at the editions of James Franklin's New England Courant that was published in the Colonial Times in the 1720s. I had identified James Franklin's newspaper as one of the first in which a journalist went to jail for publishing secrets that the government wanted to unmask or find who leaked those materials. And so I looked back at those issues. I examined as primary source material editions of Editor and Publisher from the late 1800s to the early 1990s, when I was trying to look for how the discourse of journalists' rights and the journalism profession really created itself through the discourse among journalists. And so I wanted to isolate some of the key primary source materials that helped create that phenomenon. I spent a lot of time for one chapter that was also published in a separate journal article, reviewing about 2,000 pages of congressional hearing transcripts and the archives of a congressman who chaired a series of hearings debating journalist shield legislation in the 1970s. And then I also spent a lot of time reading law review articles to assess the evolution of judicial doctrine and common law protections of journalist privilege over time. So I did sort of a lot of reading and then really tried to narrow kind of goals of what I wanted my research to produce. I also interviewed about a dozen journalists. Floyd Abrams, a attorney for several of the journalists who had been facing jail time at the time I was working on this project. Also James Goodall, an attorney. Several journalists who had faced subpoenas to reveal confidential information. Josh Wolf, Lance Williams of the San Francisco Chronicle, Tom Robbins of the Village Voice, and then several other lawyers as well. So that helped me understand kind of the current context, some of the current controversies, some of the legal challenges that journalists were facing contemporaneously. So kind of three goals of this research that evolved over time. One is I wanted to assess modern legal problems and implications. So here's where the interviews were really important. Here's where analyzing the major court precedents, so understanding something about legal doctrines and court precedents, looking at the role of 6 federal appellate decisions that rejected journalist claims in a short period of time. I developed then my writing kind of around a case study approach for the first chapter of my book to really flesh out, here's the modern journalist subpoena problem. And then identifying what problems that presents for journalism ethics and practice, and really why this is screaming out for a need for legal solutions in the federal judiciary and in statutory law, both at the federal and state level. The second goal that I had was to try to explain the history of journalistic duty, both in ethics and in law. Why did journalists feel this ethical normative duty to protect the identity of confidential sources, and how did that translate into a legal argument? So I really, a lot of history is chronological. I tried to trace this concept of journalistic duty and journalistic independence and the practices of early journalists in the colonial times and in the early to mid 1800s. And then really the profession of journalism started to develop in the late 1800s. So I tried to root that in some of the discourse at the time, the development of ethics codes in journalism schools in the early 1900s, and then following this through case law. When did journalists start taking this ethical norm and making it a legal argument? And that really, my research found, started in the 1950s, or partly in the 1950s. There were examples of it earlier. And then really how that ethic transformed into a First Amendment argument that reached the Supreme Court in 1972. And then what happened in the last generation, the rise and fall of judicial privilege protections. And then third, my third goal in this research was to evaluate the interaction among journalism ethics, law, and free press theory. So I really found that ethics was relevant to judicial decision making, that there were implications, certainly, of legal rulings on journalistic practice, that the source of journalistic rights to protect confidential sources was rooted in public policy and First Amendment considerations, and that ethical standards are not absolute, and that ethical standards sometimes um, um, can suggest different outcomes when it comes to confidential source use and protection in different contexts. So the book was organized into three parts. You'll see I maybe like this organizational structure because my second book kind of relies on a similar structure. But the first part was really looking at the problems of journalistic duty to protect sources. There's a chapter on that sort of sets out the problem, defines the terms of the journalist subpoena problem. Second chapter constructs several case studies drawing from those interviews and news reports and some legal cases. And then chapter 3, I focus specifically on one particular subset of journalist confidential source issues when it comes to national security reporting and national security leaks, and really focusing on the Valerie Plame case. So part 1, kind of the modern problems. Part 2, really looking at the historical development of journalistic duty to protect confidential sources. So chapter 4 is rooted in kind of the colonial and early American experience, really up until the mid 20th century. Chapter 5 focuses on Branzburg v. Hayes, the Supreme Court case in 1972, which is the only time the Supreme Court has issued a ruling on journalist source protection, and that's kind of a pivotal legal precedent, but not the end of the story. Chapter 6 really is one of the most unique contributions or significant contributions of the book, because it concretely, discreetly looks at 3 years of attempts in Congress to pass a federal shield statute giving journalists confidential source rights. And that came from archival materials in a congressman's papers, and also meticulous review of thousands of pages of congressional hearing transcripts. Chapter 7, The Rise and Fall of Judicial Protections, is traditional legal analysis of court doctrines and judicial opinions, and the development of common law over time. And then chapter 8, part 3, The Future of Journalistic Duty to Protect Sources, is kind of a normative, forward-looking part of the book, where I develop a model to determine who is considered a journalist when it comes to claims of journalist privilege protection, but also providing suggestions for legal development and also for journalistic practice. So the primary arguments that I came up with through this legal historical research: the journalistic duty to protect confidential sources has been a central ethical norm in the professional development of journalism, with roots as far back as the colonial era. This ethical norm has been transformed into legal principles of statutory, constitutional, and common law to varying degrees. These ethical norms support the basis for a broadly recognized journalist privilege in law, although one that is less than absolute. And fourth, the historical development of these ethical norms also provides guidance for resolving modern legal problems, including the limits of the privilege, how judges might conduct public interest balancing, and in determining who should be recognized as a journalist eligible for the privilege. So this is sort of what I had come up with at the end of this multi-year research project. What's original? Research. You want to try to make your research new, unique, original. I really think some of the contributions include that I identified journalistic source protection in defiance of legal orders was well established as an ethical doctrine in the late 19th century. That I don't think was clear in legal scholarship. The legal history of the newsman's privilege hearings, as it was called in the 1970s, was a significant new contribution. There hadn't been publication about the details of why did 80-something bills fail to pass in the 1970s at a high watermark of journalism. And another original piece in the book looked at a case called McKevitt v. Palish, in which a notable Seventh Circuit Court of Appeals judge wrote an opinion that kind of changed a lot of other judges' thinkings in non-traditional ways. And then looking at the ethical issues that arose in a number of the legal cases in the early 2000s, in which journalists were losing their legal claims. I really think that was something that was unique for the research. Finally, the last chapter really focused on when are bloggers considered journalists. So I was looking at kind of current controversies at the time, some historical pre-blogger cases that raise the question of, is this non-traditional journalist really considered a journalist? And then I created what I called a comprehensive functional analysis. When is a person considered to be a journalist? If their purpose, process, and product is similar to traditional journalists. And I sort of flesh out each one of these prongs, both using historical arguments, precedent, but also normative and ethical frameworks. So I think this was also kind of a unique contribution of this legal research. Let me just conclude. Early on in my career, I was asked to participate in this project called New Agendas in Communication. And I published an article called Freedom of the Press and Journalism Ethics in the Internet Era, in which I asked, how can journalism defined by ethical and legal frameworks continue to be a distinct discourse in the internet age? And I used sort of normative free press theory to sketch out areas of future scholarly focus around issues of professional viability, access to information, privacy, security, independence, and ethics. So this was an example, I think, partly of drawing from history and law to sketch out future areas of scholarship. So finally, let me just conclude by talking a little about one of my current research projects that I've been working on slowly over the last couple of years. Looking at a court case from 1958 in which the Supreme Court overturned the censorship of a magazine published by gay and lesbians in Los Angeles called One Magazine. And I'm spending lots of time going to historical archives to learn about who these editors and writers were that created this first magazine for homosexuals in the United States. What were their motivations? What were their goals? What was their work like? What were their lives like? And how did the magazine litigate this case by losing at the federal court level, losing at the Ninth Circuit Court of Appeals level? How did they find a lawyer? What were their legal arguments? And what was the government doing to put them out of business and to potentially jail them? The FBI was involved, the U.S. Attorney's Office, a number of entities wanted to shut this magazine down and got very close. And so my work, this is sort of where I laugh about kind of organizing a book in 3 parts, but I'm really first trying to understand the roots of the case. The magazine was launched by an organization called the Mattachine Society, so exploring the history of this era in the 1940s and 1950s. The second part, really focusing on the case, the lawyers, the people involved. So I'm digging through their personal papers, their archives, old oral histories that some of them did with other researchers. And then finally concluding with an analysis of really the legacy. Why was this little known court case so important? And so my goal is really to construct the definitive account of this little known but landmark court case. So I'm using historical archives, oral histories, magazine issues, FBI files, legal briefs, decisions, and transcripts. I've reviewed the personal papers of several Supreme Court justices who've died and now have left their papers open at the Library of Congress and at the Supreme Court in Washington. And so this is an ongoing project, but another example of my legal history methodologies in my research. So with that, I want to thank you very much. I hope this was helpful in teaching you a little about how communication scholars use legal and historical research methods.